that yet, I encourage you to read that article. Beside Doug is Mitch Rose. He's a Toronto mediator and lawyer with Gossin?
Gossin, yes.
Stancer Gossin Rose. He's been a lawyer since 1995, a mediator since 2007, and he has expertise and passion for delivering effective, practical solutions for people in conflict. He provides both mediation and settlement counsel services throughout Ontario on a wide range of civil disputes. And he's going to, you'll notice that he's sitting between Doug and our third speaker, Barry Fisher, and Mitchell's.
I had no idea why.
Keep these guys.
He's the designated mediator and settlement counsel for this panel. Barry Fisher is a mediator and arbitrator in both employment and labor relations matters. He offers 3 forms of ADR based on clients' needs: mediation, arbitration, med-art. He's from the Evaluative School of Mediation and brings over 30 years' experience as an employment lawyer and legal author to the dispute. And so they are going to engage in a vigorous debate, I hope, about this topic. The other thing I want to mention is that this session is being recorded. And so for those, we encourage people to participate, ask questions as the panel goes on. But if you could speak loudly so that the microphones and will pick you up, that will help our recording. Thank you very much. And with that, I will turn it over to, I think Mitch will kick us off.
Hi, thanks, Michael, and thanks for coming. I know this is probably not the most ideal time. It's day 2 of a 2-day conference, and late on a Friday, and but we appreciate you being here. One thing that I can be grateful for is the fact that not only did the Jays get into the ALCS, but they didn't schedule the game for today during the afternoon, because I think there would be even fewer of you here, and it's possible that I might have called in sick.
Yeah, I would have been here.
Yeah, so would you have come, Barry?
I would have come, and I obviously would have therefore won the debate.
Yes, I think.
But Barry, being the fair person he is, he would of course put across the other side of the debate.
Of course,
Naturally.
of course he would.
Absolutely.
This, interestingly, I find it interesting. Hopefully, you will too. This has really become a hot topic. This pro-joint session, anti-joint session. By joint session, we mean plenary sessions. Would be fair to say with or without opening statements, because sometimes they have openings, sometimes they don't. Sometimes there's a mixture. You can tell me if you see joint sessions as being other than with or without opening statements. But there's a lot of debate, I think, among lawyers, among non-lawyers, among mediators about this issue. And not surprisingly, I'm middle of the road when it comes to this. I have found, though, that I probably like joint sessions more as a lawyer than as a mediator, and I'll talk a little bit about why that is a little later after we've heard from these gentlemen. I'm going to turn it over to Doug first. And Doug had a paper, as Michael mentioned, about, basically a mediation with all joint session and no caucusing. And he's going to tell us a little bit about that and what he learned at Harvard and some of his experiences.
Thanks, Mitchell. I will say the full name for the article is Open Mediations, What Does Harvard Know Anyway? So the genesis of this is I took the Harvard Mediators course 2 years ago. Much like, and I've been a practicing lawyer for over 30 years as commercial litigation counsel, having done tons and tons of mediations on the counsel side. And I didn't know what to expect when I arrived at Harvard, and it's a 5-day full day course. And within the first hour, it became clear what the message was going to be, and that is precisely what I'm going to talk to you about today, and that is this idea of having completely open sessions, which was a surprise to myself, a surprise to the 47 other of my classmates. And so we were somewhat doubting, to say the least. I know I was, not ever having as counsel been, or having participated in a completely open mediation, nor had it ever been proposed to me. So it was a surprise. And so we were kind of doubters, probably as most, if not all of you are right here, I don't know. In talking to people, there are not a lot of situations that people have experienced where there have been fully open sessions. So it is difficult, and especially as lawyers, to get our heads around it. I will say by the end of the 5 days, I was a convert. I am a convert. That's not to say that it's either completely open or not at all. It's far from that. And I will certainly say does not lend itself to every kind of dispute. But surprisingly, as I learned at Harvard, and since then, I've become more and more, sorry to use the word, but open to its utility in disputes that I wouldn't have normally thought or naturally thought it might be conducive for. So with that said, it is very much the truth. I guess there are a couple of truisms, more than, but two I want to talk about. First is that every dispute that we all encounter involves people, okay? Whether it's a complete corporate dispute or otherwise. The people around the table, the decision makers, those who are listening, those who are speaking, those who are thinking, we're all people, regardless. And whether you're wearing your corporate hat, there's probably 2 hats you wear when you represent a company as the client at a mediation. One is obviously the pure corporate interest. And secondly, it's often the person who was involved in the trenches or on the front line of the dispute. And that's an emotional thing. So emotions are tied into every dispute, I would suggest, no matter how purely economic it may be. There's always emotion governing. And so that's important to understand. This is not just family law disputes. Okay, it's far from it. And as I said, I'm a commercial litigation lawyer. I do not practice family law. I've not mediated a family law dispute. And there are all sorts of situations where this can apply. In particular, obviously, those disputes where there is an expected ongoing relationship. Those are probably the most easy to pick off because you want to be able to deal with the dispute but still carry on a relationship on the go forward. That is probably a fairly rare case, but it certainly arises in supplier type situations, banks and their customer. That's a huge one, potentially a huge one, where you are trying to appease where the banks are trying to work with their customer. Whether they keep that business or not is one thing, but certainly reputationally, word of mouth, the community, et cetera. And so this certainly lends itself to that kind of situation. It lends itself to certainly closely held shareholder disputes. It lends itself to estate situations, whether it's taking care of stepdad or second husband or second wife, and the complicated dynamics between children from first, say, mother and now the new mother steps in, or using the father example as well. So there are a bunch of situations. But even in those situations where there is not that sort of continuing feel or thread, in my view, I think there's a lot to be said for the process anyway, because it's very emotional and emotion-based. It's based on a concept, and maybe I should talk about what it is. It's basically, as I said, open throughout. And again, you can have iterations of that. And with that, it's important, obviously, to have a discussion, certainly initially with the lawyers, about what they can expect, because if you just show up at a session and all of a sudden somebody says, oh, by the way, you're not getting any reprieve and you're not going to have, quiet or confidential sessions with the mediator and what have you, that would be very foreign. So the table has to be set properly, no question about that. But having done that, it's basically open. And so with that, there's a lot of, especially where it's particularly emotional based, although I would argue everything has some emotion in it, there is conflict that is expressed. And parties are encouraged, actually, to express what's on their mind, to clear, with a goal to clearing the emotional aspect. And, there's also an element of everybody wants their day in court. Well, we all know as litigants, your day in court can be a very expensive one, a very long one, a very uncertain one. And with mediations, provided you can, as a mediator, manage the emotions, manage the conflict, which is not easy. It can be more difficult, quite difficult. But if you can do that, then the parties are actually getting kind of their day in court. They're venting. They're looking the person in the eye and saying, you know what, you really wronged me. Or this is why I'm so mad. Or this is why you owe me twice as much as you say. And the other party gets to vent from their standpoint. You were a lazy employee, or you didn't take care of mom, or you didn't do this, or you didn't do that. You get it out there. And I don't know about you, maybe I've been unique in my matrimonial situation, but I have had arguments, well, now with my ex-wife and currently with my partner. And maybe it's just me, but it's kind of human, right? I mean, you have arguments. And if you don't deal with really what's at the root, everything gets sort of glossed over, and there's arguments about stuff that are 3 layers above what's really at issue. And so by getting into the emotional aspect, you get people to open up, and you get people to drive down and really get into what's really at play. And so that is the idea. It enables the table to be set to get into the real issues, to get into what's really important. And if it also lends itself to, unless the two parties are completely and utterly stubborn, which happens, but short of that, being able to look somebody in the eye and tell them why you feel wronged, to be able to explain why that happened, as opposed to doing it through a mediator where it's obviously not, it's obviously genuine, but it's not heartfelt. It can't be. What does a mediator know? The mediator has been involved in the case for 3 minutes, and maybe there was a brief the night before, or even if there was a brief 3 months before. They haven't lived and breathed this. And so you have the issues that are really driving the problem. And once you get to that, and it's only through, not only, but I think it's very successful through this process that you can get to that. And then you talk about, okay, let's talk about the real issue. And with that, you're having dialogue back and forth, and perhaps you're hearing the other side, and maybe you did attribute improper motives to them when maybe it wasn't quite as bad as you thought, or you hear their perspective and you maybe think a little bit more. And having heard all that, you are then, the theory goes, and I've seen it in practice, where you get to the heart of it and you are able to understand where they're coming from, and your range of options is increased many times over. Because you're not just focused on the dollar or just focused on this or that. You get a sense of where the other person or the other party is coming from, and therefore being able to bring these ideas and threads together in order to create more options and more understanding at the end of the day. So there's all sorts of other pieces to this, but and the last thing I'll say is that, this isn't damning the lawyers, I'm one of them. Lawyers are the problem often because we are control freaks. We are trained on the law. We are trained to protect our clients. We are trained to strut our stuff. It's not often we get to perform in front of our clients. And with that, there's a tendency perhaps to be a bit more strident than you otherwise are. In court, we can say whatever we want with whatever venom and passion and without any sympathy to the other side or empathy. You say what you want, and this is what lawyers, by way of knee-jerk reaction, they do. And so part of this, the problem, or part of the challenge, is get lawyers' heads wrapped into this. So they move from a protector advocate into a protector facilitator, and I think that's a very important aspect of this. Okay, I've gone on long enough for now.
No, it's, so before I actually open this up for some questions.
Why, is there a counter view over there?
Well, and before we get to the counter review, which might also come out during the questions, I don't know. There's one thing I'm curious about, and that is when you've been hired to do the type of mediation you just described, so it's fully open, do the parties or do their lawyers know that this is the kind of service you offer? Are they coming to you with that in mind? What's your experience been?
Well, I've only been at the mediator game for 2 years, so it's a work in process. I certainly, there have been a couple referrals where
Right.
it's based on what actual mediations I've had in that regard. But short of that, it's certainly to lay out what the menu of options are. So get contacted and say, and I'll say it first because I believe in it. I'll say, have you ever thought about this? And let me tell you why it may be of interest to you. And clearly, you've got to have laid that groundwork because, again, you can't just show up and say, hey, here's what we're going to do today, because there's a lot of expectation that I wouldn't have with the client, but the lawyer needs to tell their client, look, this is unconventional, this is not maybe what you've done before or what you've heard about, but here's the process and let's give it a try.
Okay. And typically, what types of disputes are these? Are they commercial disputes that you're mediating?
Yeah, that's
Yeah.
kind of my bag, and it's
Yeah.
sort of a different spectrum of cases within the commercial area. Yeah.
Okay. And are you finding that, one area that might be particularly ripe for this type of mediation might be a family business dispute?
Certainly, and where there's, I mean, it lends itself most, I'll say obviously, although there's nothing obvious about any of this, it lends itself to situations where it's not just, thanks for the check, we'll see you later. It lends itself to situations where there's a reason, either an actual ongoing relationship, so a family dispute, or a supplier situation, or even a business that, reputationally, you don't really need this. You're concerned about what's said, what's not said, or what the community thinks. The other aspect is, in business, I guess it may be a big corporation, but especially owner-managers, my goodness, they are so tied to this. It's so emotional. This is their heart and soul. This is what they've mortgaged their house for. I mean, there's a ton of emotion involved. So by labeling it commercial, I don't think it takes away from the fact that these same principles apply.
Okay, thanks. I mean, I think what I find particularly interesting and incredible about what Doug is saying, even though I don't have any experience with this type of mediation, and I'll talk a little bit about that afterwards, including my experience at Harvard, which was very different. I think your experience was
Mine was the
different as well.
mail-in course, right? So.
Oh, I see. Okay.
So,
Well, you missed the best part, which was going to Harvard.
Yeah.
Being in Boston or I should say Cambridge for a week.
Yeah.
Yeah, you have to be careful not to say you're in Boston.
When did you do the Harvard?
Well, in 2012, and what's
Interesting.
interesting, I think, is that
It's recent too.
yeah, that wasn't the course. So it must have been taught by different people at the time. I don't know. I recall somebody on one of the days. It's a 5-day course, and on one of the days, I believe somebody talked about what you've described, and it lasted about an hour. And I'm pretty sure that person was a family mediator. And so I've always associated this type of mediation with family law. And so that's why I found it very interesting that you're a commercial litigator and you're promoting an entire mediation that's entirely a joint session without caucus, although in your paper, you did indicate that you can tailor make the process, you can adjust it a little bit.
Yeah, and it's
To
certainly,
suit needs, yeah.
certainly, that's part of the process, if you will. It's the first process, is to talk,
Right.
to deal with the parties, to create the process under the, if parties are actually involved in creating the process, then, in my experience, they're more committed to it. Or not just being told that this is what's gonna happen, they're, okay, well, this works. So just very quickly, so you could have, you could have open sessions on the venting of emotions, okay, for example, and then that could switch into private caucus.
Right.
People having had their expression of their emotion and hopefully other sides getting a better understanding of where the other party's coming from.
Okay, thanks. So on that note, does anyone have any questions about the topic for Doug?
I've got a comment.
Yes, sir.
I just find this really interesting because I'm a non-lawyer mediator, and I got my original training through the community mediation programs. And I remember about 10 years ago at an ADRIC AGM, I think there was a panel on mediation, and I remember lawyers walking in like, oh, that touchy-feely stuff.
Yeah.
And it's really interesting hearing a lawyer talk about touchy-feely stuff, because what you're saying is absolutely true. Everybody is a human being, and everybody's got emotion. And if you don't, and a lot of issues some settlements stop because they're not being heard emotionally. And that's the whole basis, I think, I do more family. And I think that's the basis, when we're going to a mediation room, is that we're dealing with, not a corporation, but we're dealing with people. And I know it's difficult for lawyers, and Barry loves to talk about touchy-feely. But I just find it very interesting hearing that coming out. And if anybody trains in the community aspect, it's all touchy-feely. It's all touchy-feely. It's getting into the emotions.
Yeah, because there's no money and it's not law, so what else do you have to talk about? If you have a dispute with your neighbor about something, it's not a legal issue, it's not a monetary issue, so touchy-feely matters. If you're dealing with issues which are monetarily based,
But within that, there's a human being, and somehow
Absolutely.
you can touch something that will trigger.
yeah, their wallet.
And their wallet is usually right up here in their coat box next to their heart.
Well, we could step outside and caucus, but, that would defeat the purpose.
And I also did take the Harvard course. I took it before both these guys. And there were two streams, and you didn't have any choice as to which one you went. I didn't know the difference. I took the same stream as Doug. I took the same course. I heard the same rationale, and I have a different opinion as to whether that's useful at all. But I ironically took the same course.
Yeah, I know you're successful, and I know you have your evaluative, and that works very well.
Any other questions so far? We'll open
So
it again we're going to open it up for questions as we go along, but, so, I think you had your hand up first. I will come back to you.
Yeah, I missed Barry's presentation, but from your attitude,
No, I haven't done it
He
yet.
hasn't spoken
I haven't
yet. You missed
spoken-
nothing.
I haven't spoken
oh,
yet.
I didn't miss anything.
No, you didn't miss.
I did the Harvard thing too, a longer time ago in Republic either. But, so I'm interested in hearing whether you ever.
Someone's gonna say, I went to Harvard in 1862.
Yeah. It's a contest. We went to Harvard first.
Confederation. So what I was interested in is obviously there's a value of parts of it being together at certain times. There's a real value even in what you're talking about, Doug, if you're putting together a solution, particularly if it's complex, coming up with creative solutions. Sometimes in part you think about this and you think about that, all the way going back and forth. So you say you do that.
Yes.
Okay. Sorry, I think in the first row, you. Well, that's okay, you don't have to, then we definitely want to hear from you.
I'll ask my question first.
I tried to
Well, I was
unlearn
just wondering,
everything.
So thinking about the venting and the emotional texture that comes out and that idea of people wanting to sort of get their pound of flesh when they're doing court and all that kind of thing. Where does that fit into the sort of thoughts of learning about trauma-informed mediation and trauma-informed legal practice? I work in I do mediation of human rights complaints in a small community where many people already know each other and where there are sometimes lots of reasons why people would want to be in continued contact or inevitably would be in continued contact, but where there has been a harm that relates to dignity. And I think there's some way that you can prepare, and I've had some good success doing what's almost like a restorative process, that you can call it whatever you want to call it, but it's getting everybody in a room with some preparation, letting them kind of say what they have to say. I just wonder where trauma fits in there, and whether or not they taught you anything at Harvard, or whether you come up with any solutions or practical suggestions for how to see the venting as not necessarily a neutral thing, but that rehashing trauma can be something really harmful and can create a new harm.
I must say that that is not something that I have familiarity with. It's not something that they touched on at the Harvard course. So I can, I could try, and I don't think I would have a very satisfying answer for you, because I really, that's not what I've done. But I could, obviously, the re-triggering, that sounds like it's very problematic and would be very difficult and have to be very, very, very careful in how it's put out
I
there.
think the things I'm often mediating are allegations of somebody has said something, whether it was racist or discriminatory in some way in a workplace or in a service setting, and putting those people in the room inevitably is going to involve probably the person, and no public education and rehabilitation has happened yet for the person who was accused of saying the racist stuff or whatever form of discrimination or harassment that might have taken. So putting all those people in a room without it just
Without
anyway.
the sort of the support behind it.
Well, it just seems like more racist stuff would get said, I guess.
Yeah.
And
Well-
it would end up with a new complaint.
I guess it depends on the need. I mean, there are certain ones, say in an employment context, where there may be somebody in the company said this, and the company gets sued, and the individual, and what have you. But just on not just, I don't want to minimize it, but on just in human terms, to be able to say to somebody, you know what, you really hurt me. And for the person who did the hurting to hear it, and obviously the person they have to be of a certain type of person, an openness, if you will. And for that person to say, you know what, I see it hurt you, I'm sorry. Okay, the value of that is massive. Now, I'm not saying it's easy to get there, but it's massive. And if you're in a completely caucused mediation, you don't even have an opportunity to do that.
So I guess I understand a little bit better. This isn't a model of that we're together the whole time.
It can be.
It can be.
I'm actually suggesting
Okay.
that those kinds of mediations happen. I've done them, and they can work. Not in every situation.
So I think actually, and I know some people had their hands up, and I promise.
Thank you for that, sorry.
Oh, no, thank you. I will come back to you if you've had your hand up. Just remind me again afterwards, because I think that last question creates a perfect segue into having, to hearing from Barry, because some of the things you talked about are probably a lot of the things that you have dealt with when you're doing labor and employment mediations, and there are human rights violations, allegations of violations of the Human Rights Code.
Certainly allegations.
Right, okay. So, And so the issue of trauma is coming up, and so tell us about that from your perspective.
Well, according to Doug's theory, the mediation should go something like this.
Harvard, by the way. No, they
Doug
stole it from me.
It's the Doug theory.
Sorry, what's your name in the front? Sean. Sean, I just want you to know that when you fired me, I felt horrible about it, and you're a bigoted, racist pig, and I hope you fall off the face of the earth. But I'm really glad I got that off my chest now. And then Sean will turn to me and say, well, you know what, Barry? I always actually thought you were a completely incompetent employee. I don't want to pay you a freaking dime, and it's important that I got that off my chest. Now let's figure out how much money I'm going to give you, okay? So I took the Harvard course too. I unfortunately got in the same section that he got in. I had been a labor arbitrator for many years before that, so I wasn't some babe in the woods. And the entire process was completely antithetical to anything I understood. It made no sense to me. I came from a labor relations world. If there's a world of law which is based on continuing relationships, it's labor relations. More than family. I mean, they hate each other, and then they might have to pick up the kid at the McDonald's and stuff. But in labor relations, these are ongoing relationships. They never, ever want to be in the same room. You would be laughed out of existence. Your survival as a mediator or an arbitrator in the labor relations world would last about 5 minutes. So I started thinking, these are the people, they've been doing mediations and labor relations when the rest of us thought it was yoga, it was meditation, okay? So
It's not.
it's not. So they know more about, they knew at that time, now the civil guys have caught up, they knew how to, and they've learned that that just doesn't work. Why doesn't it work? For a million reasons. Let's just go over some of the issues. Venting assumes that the ventor feels better and the ventee gets it. You call me a frickin' idiot, I'm not going to turn around and say, oh, I feel your pain. I'm going to launch back. That's exactly what happened. So what do? You have two angrier people. I had a case the other day. The lawyer came out to me. This guy had been fired, I don't know, 2 years ago. And the lawyer had said to me, you know, you got to work with his emotions. He's very angry, et cetera, et cetera, et cetera. Okay, fine. I said, I can pretend to be empathetic as the best of you. I walked in the room. He was saying, I think, I understand that I'm entitled to reasonable notice and the range is this to this. He wanted to talk money. Of course he wanted to talk money. So I talked to the lawyer, what are you talking about? Well, when he came to see me a year ago, when he came to see you a year ago, he was just out of a psych hospital. He's now better. He wants to focus on getting a resolution here. I'm not a psychotherapist. I don't know if any of you are. They don't hire us to explore their feelings. They hire us to get a deal. They may still be screwed up after spending 3 hours with us. They may still have multiple health problems. They may still hate their wife, but they got a deal. That's what we're hired to do. We're not hired to change their lives. We're hired to get a deal, fix one little part of their life, and let them move on. So, unlike people think, I don't force my opinion on people. I say to the lawyers, do you want to have a joint session? Since I started asking instead of doing what I think they want, and in three or 4 years now, I do about 200 to 250 mediations a year. Only once last week, in a non-employment case, did all the parties do a joint session. And they didn't even agree. The defendant said, if we don't have a joint session, we're leaving. So the plaintiff capitulated. It was a complete disaster, but I won't get into that. So of about 1,000 mediations where I have asked, yes, the lawyers, because the lawyers represent the interests of the clients, they've never agreed to do a joint session. I've never had a plaintiff's lawyer. I have never had a plaintiff who wanted a joint session. They fear the joint session. When I tell them you don't have to see them at all, I take them to their separate room in the beginning. They never see the other side. And when it's over, I have what I call the the awkward elevator moment. I actually hold back one party while the other one goes down the elevator. They are so relieved. So this myth that plaintiffs, at least in employment cases, want to vent to their employer is the thing. They vent to me. I'm a wonderful listener. I'll listen to you tell me about how horrible your boss was, and I'll say, I know, that's why I'm self-employed. He sounds like a complete jerk. And then I'll go into the employer's room, and they'll tell me what a horrible employee she was, terrible performance review, and I'll say, I didn't hire her, buddy, you did. So they're venting to me. I translate it. So that's two reasons. Let me see. I've given this spiel about 4 times now, usually to personal injury types. And when I drill down with the personal injury lawyers, why do the plaintiffs want to do it? No, they don't. I know they don't. They do not want to talk. And never has a plaintiff's lawyer told me they want to talk. It's the insurance adjuster. The insurance adjuster seems to think, as the guy told me last week, my failure, of course, was a non-employment case involving only insurance companies. I have to see the whites of their eyes. Really? You've done 5 days of discoveries, you've read every medical report, and you somehow think you're going to be able to determine how well this guy will perform in court by listening to talk for 3 minutes? And when you drill down with the PI people, it's all because the adjusters have this belief system that they need to see the person. So I personally, I don't know about you guys, but I don't think we're supposed to design this entire industry around satisfying the needs of insurance adjusters. The theory of the joint session is you're going to take a lawyer who for 20 years or 10 years or 2 weeks has been taught to do what he's going to do, and because I tell him to change his style, he's going to. He's not going to, or she's not going to. They are going to do what they do. They're going to play act. They're going to pretend they're in court, because it looks like a court. You've got 2 opposing sides talking to a third party. Now, why does that kind of work in court? Maybe not. Because that third party is the guy you're trying to convince the judge. At a trial, you're not trying to convince the other side of the rightness of your case. You're trying to convince a judge or a jury. Mediation is not about that. Mediation is not trying to influence a third party. You're trying to influence another person to come to a deal. So the skill set that works perhaps well in a trial of adversarial, which lawyers are trained to do, does not translate well into a mediation, because they still talk to the mediator as if he was a judge, and they don't talk to each other.
Barry, I'd argue that's exactly right.
Yeah, but I'm not going to change.
That's
My job is not. No, it's not the problem. The problem, I've been hearing this stuff for 20 years. It's not the lawyers' problems. We are not going to change lawyers. Okay? If you think your job is to get lawyers to be better so they act more like you as a mediator, then keep on writing articles, keep up whatever your other practice is. We are serving the legal community and their clients, and they're not going to change. We have to change. We are adapting to the way they resolve disputes.
I want to come back to Doug for a second.
Okay.
Well, first of all, Barry, I'm glad that you've had this opportunity to vent.
I've done it many times.
If I understand you correctly, just make sure I understand you correctly. This is a bit of an emotional issue for you because you feel so strongly about it.
I've been battling the training. I've been unlearning the training I've had for 20 years, correct? And they keep on training the same way.
It's a lot of trauma.
Okay, well,
I can deal with it.
and again, if well, let me just talk about the joint session you talked about. And I agree. Joint sessions without openness after that are hugely dangerous, because you go to a mediation and you're there to try and resolve something, and if the only time you're together is listening to F.Best tell Barry Fisher, we're going to be practitioners for a minute, F.Best talking about your client and how awful he or she is, and then you saying back to me, my client, that we're awful, and then you split away. Well, that's the worst of all worlds. That I agree with, for sure.
Okay, good.
Okay? But what I'm saying is that if you have that, you should actually dissuade lawyers from being conventional lawyers in a mediation. These things work when lawyers kind of are able to step back a little bit, let the mediator manage the situation, to ask a lawyer to just maybe soften it a little bit, and some will and some won't. A lot do, actually, surprisingly, when they're sort of advanced, they get a sense in advance of maybe rethink this because we're going to be together the whole day. So this isn't about strutting your stuff, lawyer. You do that in court. And I know it's tempting. I've done tons of mediations, as counsel. And this is your chance. Your clients only get very, very few, or they get very, very few opportunities to see in action. And you want to make sure your client knows that you're on their side. So there's an absolute tendency, we all get into that for sure, to take positions and to downgrade the other side and if you do that in a vacuum, it's disaster. We agree completely on that. But what I'm saying is that this isn't about telling the lawyers what to do. It's the lawyers actually releasing things a bit. So they become more facilitators than advocates. And that's not an easy piece.
So
I agree with
in
that.
other words, your whole theory is based on the premise that you can change the behavior of the legal profession.
No, it's
I agree.
not, Barry. It's not, because it is, 30 years ago, right, people would have had very strident view. Are you crazy, mediation? Is that nuts? That's not what lawyers do. Lawyers are in court. You have to advocate for your party, your client. Mediations? You're nuts.
That's because they didn't know what mediation was.
Well, but Barry, it's the same principle.
No.
It's different.
Lawyers
It's different, so it's different. That doesn't mean it's wrong. Just as 30 years ago, mediations were different, and look where we are now. We wouldn't have this conference if people didn't believe in mediation.
But
We're
lawyers-
arguing though about mediation. Like,
Lawyers
what is
have
mediation?
become really good mediation advocates because they've learned that's how you get better deals for your
Well,
client.
but that's where we disagree, because I don't think that is the case, and I think that you get more, potentially, this isn't a science, it's not formulaic, potentially, you've got a lot better opportunity to get deals when you have an ability to talk it through in some managed form and get away from these principle-based stuff and into interests.
Okay,
And you
let's-
have a whole, you broaden the menu of options, you broaden the possibilities for settlement. And you also, through a process where everybody's together, the clients themselves are not being told by a mediator what so-and-so's position is. They're hearing it straight up, and you're going to have a better understanding of, okay, that's where they're coming from. So maybe, this term that they're trying to get, I understand it better, and maybe we can work with that, provide over here, this is meant.
Okay, I think a lot flows. One of the things I've learned over the years by giving these various speeches, it is very dependent on practice orientation and geographic orientation. I just came back from a conference, the International Academy of Mediators in Vancouver, which is mostly Canadians and Americans. And California, they call it the California model. They don't never do joint sessions. It's very interesting. So there's mostly geographic, but there's also a practice-based. In employment law and human rights, George Wood, in 99.9% of the cases, the relationships are ended. The only thing is money, okay? There's none of this apologies, reference letters, whatever. You are talking about money. You are talking about a dismissed employee who's entitled to some entitlement in law. It can be quantified monetarily. There's not a lot to talk about in terms of interest. My interest is I've lost my job. I'm about to lose my house. I need money. The interest of the employer is we had no idea when we moved to Canada from Alabama that you had these crazy laws. Why do we have to give you everything? They can talk till they're blue in the face. I walk in, of course, the lawyers have already told them this. I said, that's all very fine. I know you feel terrible about it, but this is an evaluation of what a court is likely to do. Let's talk about the money. There is no other interest. There is no other means of resolving it. An apology letter costs nothing, and it usually means nothing. So maybe in commercial transactions where there's ongoing things, and if I give you this, you give me that, but in transactional mediation where the only thing is the defendant, we're trying to figure out how much money the defendant's giving to the plaintiff, that's it. That's every insurance case. How much money is Manual Life going to pay to the plaintiff, period, end of story. So it's distributive, there's no extra value, all that stuff I learned back in Harvard. And so perhaps where there's actually give and take and need to understand, there's no need to understand in a lot. There's a commercial transaction, there's laws that apply. The employer simply wants to pay as little as possible, and the plaintiff wants to get as much as possible.
So on that note, I just want to make sure that we get to some of the questions.
Sure.
And on the right, yes.
Hi, I'm from Halifax, and Shelley is my name, and well, Barry, we're in 2016 now, and
Almost 17.
So I just thought I would mention that I don't know what you do, but in Nova Scotia, we do a lot in employment law.
Yeah.
Especially human rights and labor in joint sessions.
Okay.
In human rights, we do a lot of bringing all of the parties together to try to settle. And so I think, and that's a big deal. I mean, I know from an employer's perspective, I agree with you on money, on settlement cases. It is about the dollar, okay? But sometimes for the aggrieved party, right, it is often about getting that CEO or that business owner, okay, in the room, okay, and hearing that apology face to face, and often that can half the settlement amount.
That's exactly why I'm opposed to it. That's exactly why I'm opposed to it. Because employers will use apologies to save money. I was once at one of these seminars where a mediator stood up and was so proud to say that she settled a human rights case with an apology. And I turned to him and said, the plaintiff's lawyer should be fired. That lawyer didn't do his client a good service. And if you think that as a mediator,
Had that amount of damages in the first place.
it was probably an insincere apology. The employer acknowledged they could save money. I'd apologize to you for anything, any day of the week, if it saved me money.
I'm just suggesting that there's probably times, there are times in severance negotiations where I agree that it's probably not worthwhile to have the parties.
I agree with that as well.
But there's
It's
lots
not for
of
every
times- but
case.
There's lots of times in workplace, you're talking employment, there's lots of times in workplace where mediation, okay, and having the parties together, as Doug's talking about, joint sessions are.
I mean, ongoing workplace disputes, I totally agree.
Okay, so I just want to make sure that everybody gets a chance
Sure,
to speak.
sure.
Although I said this was a hot topic, so if you didn't believe it before, now you're seeing it. But I want to make sure we get to a question. So the gentleman in the middle.
I totally agree with Mr. Fisher. Now, sorry, what's your name? Yes, so 2 points. They're not mutually exclusive. I think one might be more closely related to post-termination, one might be pre-termination. I'm from represent employees in the workplace. And during those sessions, it's not about the money, how this person's action made me feel, especially when it has to do with human rights or so for the members, I call them members, they want to be in the room with the manager about what they did and how it made them feel. And I think a lot of the times the mediation actually works in that situation. So termination, I find that the members don't want to be in the same environment. So I think there's both situations work, but it just depends on at what point and if it's post or pre-termination.
The other thing you're missing, like, I don't go back and forth carrying numbers, okay? So in that human rights case you tell me about how the manager, how the employee felt all bad and she cries, whatever. I'll go back to the manager and say, you know, she's very, very upset. She started crying at one point. It was quite amazing. Blah, 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 blah. In other words, I'm conveying the emotion if I feel it's going to help with getting the deal. If she rants and raves and calls him a racist bigot and he cheats on his wife and he gropes women on airplanes, and I don't think that's going to be helpful in bringing the case along, so I'm editing. So I'm taking that emotion, and honestly, sometimes I think it has more credibility when a third party comes in. Like I did one today. I can't believe it is. I used a baby as a prop. It was awesome. But anyways, I literally took.
Why am I not surprised?
I literally took. It was a pregnancy discrimination case. I literally brought the baby in to try to get an extra 2 G's out of the employer. But I know this lawyer on the employer side knows me. And I said, I said she's an impressive witness. She's not angry with you or anything. I'm telling you that as a third party, when I look at her, she's impressive. Now, I think that means more to the other side than showing the emotion directly. So I convey the emotional component, I edit it, I control it. I totally agree. It's about control. As a mediator, I want to control the process. That's another reason I like the joint session. You're giving it over to the lawyers, and they don't know what to do half the time. So I can moderate the effect of the lawyers. Yes. Sorry.
One thing that strikes me in your discussions is that you both outlined something that works for you each, and
Works for the
what
clients.
you haven't discussed is what skills the mediator brings. It's not one size fits all. Not all mediators can do a complete joint session. Not all mediators can do totally separate. Can you talk a little bit about the personality that the mediator brings to it and how that might engage your choice of joint session for all parties?
Certainly, and I think that's an excellent question because it depends on your mediator style. It's not one size fits all. As this gentleman referred to, I think, in the first comment, this is touchy-feely stuff. And I am, for a commercial litigator, I'm pretty touchy-feely, quite frankly.
I knew it was written on the washroom wall.
Right. No, but my point is that it is, if you don't believe in the expression of feelings being important to it as a mediator, there won't be any sincerity to it. It won't be real, and you can't. I would say that you can tell a real apology versus a faux one, and you can tell real empathy as opposed to no empathy, that it's just window dressing. So absolutely, and it doesn't mean one's better than another at all, and it's not one size fits all. But I guess what I'm trying to, this whole idea of open mediations is so rare. And I think it has a place. Not in every situation, not saying it does, but I think it has a real place. And so, yes, a mediator has to be able to have some ability to control the emotions that are going to be flying around in the initial part.
And
Absolutely.
feel comfortable doing that.
Absolutely. Otherwise, it is disaster because then it's just going to elevate the dispute and increase the emotion. So absolutely, the mediator has to have certain skills for this kind of thing, and a mediator needs different skills or similar ones, but not identical in other situations.
So,
Why is it always Christian of one style or another?
I'm sorry?
Can't you have pre-mediation session and then have a joint session?
okay, so
Yes.
I'm going to thank you for mentioning that, and I am going to come back to whoever had a question as long as time allows it. So I don't want to cut anyone off. But I'd like a chance to speak. And the first thing, beyond the few words I've said.
If Barry had his way, you're the mediator. You have no place. It's up to you have every place. You shouldn't have been letting us talk.
But, well, you see though, you're both right. And that's really my point. In fact, and then, turning to the audience, I think there were a lot of valid points. So, there's a few things that I think you can draw from this, first of all, to your point, Barry, about the type of law or the type of dispute we're dealing with and geography. They play huge roles. And it really does make such an impact, because I was at the same conference as Barry, and we heard from, the people from California, and they're completely anti-joint session, and then you could hear from people from other countries, and their experiences were totally different. So, it's not like one's right, one's wrong. What I like particularly about the Toronto marketplace right now for ADR is that there are a lot of choices, and there's not one size fits all. But what I think is really important, though, as a consumer, and I'm both a consumer of ADR services and a provider, because I practice law as well, is that you have that choice. But what's really important is that you know what you're getting. So I want to just make a point for a second. If I have hired Barry as a mediator for, and notice I didn't say use Barry, we learned that in Vancouver. Were you there for that? Yeah.
No,
I said, never say you use it. People say you use a mediator. It's terrible. Somebody said, yeah. So now I watch my language, because I don't want to be used. I want to be hired.
I think the word is manipulated.
Oh, well, okay. There's that. That's a whole other session. I've hired Barry before, and Barry is not going to be insulted by this. I hire Barry for certain employment disputes, because I know, first of all, what I'm getting, and there are certain disputes where I think Barry is perfect, and I think there are certain disputes where your style isn't particularly suited for the dispute or the parties. And I think most people who hire you, hopefully, know what they're getting. They know you, and they know what they're getting.
They certainly know about the second mediation round. They don't always know what I'm like on the first.
No, but so if you don't know what you're getting, it could be a problem. So I think, first of all, you have to know where you're practicing. If you're a lawyer, if you're a paralegal, if you're a non-lawyer who goes to mediations, what's local custom? It's going to play a big role. What's the local custom within the area of law, not just geographic? Do your research on the mediator, and know yourself, because it's really, really important. At the same time, I think it's phenomenal that a commercial litigator, and I practice employment law, but I also do, I handle commercial disputes as a lawyer and as a mediator. I think it's phenomenal that a commercial litigator has been converted, I think was your word. So we're seeing the zeal of the convert today, has been converted to something that is completely different, and it's usually something that's been a domain of, I think, family lawyers or community mediation. And so if I had a particular dispute as a lawyer that I thought was that this type of open mediation would be suited for, I think that's great that I have that option. But I would want to know that that's what I'm getting into. And I think what gives somebody like Doug a lot of credibility, which is one of the same reasons why you have a lot of credibility, is because you know the law very well. And it's another reason I would come to what I would hire Barry. But you know commercial litigation. And so somebody hiring you to do an open mediation on a commercial dispute, the fact that you have a background in litigation and you are an active commercial litigator, I think lends a lot of credibility. Whereas, I think this is my own experience, so I'm only speaking from my own experience. If I had a commercial dispute that I was handling as a lawyer, and I recommended to my client to have somebody do one of these fully open mediations, and the person's background was not as a commercial litigator, not even as a lawyer, perhaps they come from a different line of work, which is fine, but they may be reluctant to enter into that kind of arrangement, that kind of mediation with that. Whereas, as I said before, you're bringing a certain credibility to the table. So I think it's really important, first of all, to be aware, because there really isn't any right or wrong. And you will really, I think, help minimize those situations where things do go off the rails, where you do have an opening session and it blows up, and you either spend the next hour or two, calming them down and, hopefully getting them to stay and just talk, even in caucus, or it just blows up completely. you know, you're going to minimize those situations because at least you know what you're getting. So I think really a lot of it falls on the consumer, and it falls on the provider to tell people and educate the public about what it is you do, which I know you do because you say on your website, or it's on mediator dates.
No,
I'm an evaluative mediator.
That's exactly why I do it.
You
so
know
there's
what
no
you're
misunderstanding.
you're getting, which is interesting. Doug, do you promote the open mediation concept in your promotional materials for mediation?
Not in the materials per se.
Okay.
Because typically the consumers are lawyers.
Right.
And I had the same reaction. I was going, what? And I think it's something that has to be discussed. So I'm contacted and I'll say, by the way, I just want to raise this with you, and here's what I think the value is in this approach. And don't get me wrong, it's somewhat new. I certainly didn't experience it as counsel. And so I guess just like business development through my commercial litigation, it's one file at a time, right? You know, and until you've seen it, until you've experienced it, it may resonate in some respects, and it may be of interest in certain files, and it's one file at a time.
And we're going to get to the questions. I just wanted to add one more thing. I still have the chance because we're coming. I think we have until 4:15. Is that understand? Okay. Okay. Well, I'll use 2 minutes and then we'll make sure we get to the questions. One thing I've found, because I mentioned I'm an active lawyer and I practice as what I call settlement counsel. Okay, so I'm not a litigator anymore. I'm going to a lot of mediations as an advocate, and one of the things that I think is helpful to realize is that as a lawyer, I actually like joint sessions more than as a mediator. And one of the reasons is I can control my own behavior, and I hope I know how, to diffuse or ignore, if necessary, the other side's so-called bad behavior. Okay, so if I'm in a joint session and there's an opening statement, first of all, I can control what I'm going to say, and I'm not going to treat it like I'm addressing a jury. And if somebody on the other side says something that might upset me or upset my client, I feel I have the skills to be able to deal with that without the whole session blowing up. But as a mediator, it's harder to control the process because I can only educate people so much, and but for the most part, I think part of this process is you got to let the participants not run the show, but you need party autonomy is important, and so part of that I think is not forcing anything on them, and which I think we would probably all agree on that, and talking about things that we probably all agree on as well. I just want to make sure that I don't forget my prop. So we're talking about the things that unite us, and so I'm sort of bringing out the flag, so that we could all end on a happy note. Go Jays! But as long as you're all Jays fans. So I mean, I just want to say that there's no one way. It's good to hear about extremes, but there's a lot of middle ground. There's a lot of variety in Toronto. Okay, so I want to make sure we get to the questions. So somebody at the back, yeah.
Yeah, just put back to Gary's point about 99.9% of the cases in employment are settled or their goal is money. And I think that would probably work ideally in the private sector. I focus on educational law. And in the public sector, a professional's reputation is more important than the future employment than money. And so I would like to use that balance in equation to the other part. I think in the public sector, reputation carries a lot more weight than the law. It might be pertinent when a person is due to retire to think, okay, I can leave here with a bag full of money. But if a person has gone through academic training, has worked in the profession for 15 years, and still has a long way to work, their reputation means a lot more to them than some dollars in the bank. Because inevitably, they never get a settlement, a financial settlement that outweighs what they would earn with another 15 years of working. So I just wanted to answer that question.
Yeah, could you give me an example of what the conflict before you would be involving? Is this getting tenure or not getting tenure?
Not
So this would be a teacher being dismissed?
Constructive dismissal coming into play, and
This would be in a non-unionized environment.
no unionized.
There's no constructive dismissal in a unionized environment, but that's another issue.
Okay, that's, we're gonna go off on a tangent. You
But
can
in
discuss it in
In
caucus.
terms of, I disagree with
Yeah.
your correlation between private and public. I do a lot of public work too. I would agree with you that reputational interest is a valid interest held by many people, whether he's a skilled iron worker or a teacher. So reputational interest is at play. And we deal with that in various ways. The employer may, give a positive reference letter when they don't really mean it, may agree to shut up, may not report the person to a regulatory authority. So I agree with you that reputation is important, but I don't think it depends on whether you're in the private sector or the public sector.
Thanks. Mark?
A slightly different spin on this debate that I'm interested in your perspective on. Earlier today, for anybody who missed it, Colin Brannigan gave a great presentation on online dispute resolution. And the quote that you tweeted from him
Yeah.
was ignoring ODR will make ADR irrelevant.
Right.
For the future of mediation, is it worthwhile to change the public perception away from it being a process that requires everybody to get together at the same time in the same room to allow them to better embrace the future trend of mediating online?
I'm sorry I missed the presentation.
I can show you my tweet. If you-
But I will say, I mean, in any context, my own experience, and if it's not face-to-face, it's just not effective. And I know nothing about online dispute resolution. I'm just talking about my general business experience, or being on on our executive committee and having face-to-face meetings as opposed to video conference. It's night and day. So I mean, real difficult disputes, it's hard for me to fathom. Maybe I'm going to be the person who's saying, that can't happen, and somebody else is going to have a differing view.
I think Colm is going to have a differing view on something. Am I correct?
A wee bit of a different view. You have to forgive me, I didn't take the Harvard course. So, I think when I first heard this kind of debate a number of years ago, I was horrified by what Barry was saying. But now I agree with him. I think we really have to look at a couple of things. And one of them is not subscribing to one model, which people have said. This debate reminds me of going between a valiant and facilitative.
Exactly.
I think it's more like, how many angels can dance in the head of a pin? I think what we need to do is, with respect, we need to do a better job of marketing to our clients so that people know what we do, right? I mean, I work in a fair amount of work that Henry and Mark does in the condominium sector, so we do the same lawyers over and over again. But I'm often surprised when lawyers don't take the time to check you out, as Mitch was saying. They'll pick you to do a mediation, but don't bother talking to you before. And I try and have a conversation before. But I think we need to give up this idea that somehow or other we're the process experts and we get to push our views on people. I think what everyone said today was really interesting and works. We work on a spectrum, a continuum. We don't work at extremes. And I think that we really need to, revisit that a wee bit instead of taking positions. We need to be able to be, we talk about inclusion. We need to be more inclusive ourselves with some of our theories. That's just my comment, as I said, without going to Harvard. So. Yeah.
And you're still a good mediator, even though you go to Harvard. And actually, the interesting thing, what Colm has done, and this was just out of mediation that I hired you for, that turned into a meet-arb, which was interesting. It wasn't planned as that. Colm, you talk about during the joint sessions, I think you call it storytelling. Is that? Yeah, which I like, because then if you're a lawyer, then you're thinking about it in a different way, and if you're a party, you're definitely thinking about it in a different way. I get to tell my story, and you manage that, I think, quite well. So what's important also, being able to manage the joint session is, as a mediator, is vital, and I think that goes to somebody's point or a question before. We'll try and get to some questions quickly, but we're just sort of nearing the end of our time. The gentleman behind Colm.
I never have the answer to my question, why these are two opposing approaches, why you can't marry the two. It seems to me it's perfectly possible to have two pre-mediation sessions with each side separately, to let them to wait and put that time, and then have a joint session working out, having gotten some steam out of the situation, and also being familiar where they're coming from as a mediator so that you can conduct the joint session.
There's no limitation, there's no reason not to. And in fact, one of the tenets is to allow the parties to be part of molding the process. And so the process can be anything you like it to be.
And what I was going to say is, typically when I do mediations as a mediator, that's what my mediations typically look like. They are a blend. Probably most of the time we're caucusing, okay, for various reasons. But we taught, and some of that was touched upon, both in your paper and I think during the discussions. But you know, I'm speaking with people on the phone beforehand. You know, so I'm learning a little bit about what the case is about, and you know, are there going to be any issues I got to be aware of, and that kind of thing. You know, then I'm talking to them alone when they arrive, and then we're typically doing a joint session if they agree. Sometimes I discourage it, but so we are getting a blend of both. It is a hybrid, and I don't know if this is everyone else's experience. My experience typically as a lawyer has been, you know, usually there's a joint session, usually, but not always at the beginning, and then you break into caucuses. That's typically what I've experienced in Toronto, in other parts of Ontario. Okay, so I want to make sure your question was answered. Okay, man at the back, you're okay, sir? Yes.
I was a participant as Canadian counsel in California mediation, and this California mediation, I understand we were defendants, my client, and I understand now, after going through it, why the plaintiff picked the chosen mediator. It seems that he wasn't any different from what I hear now from other California mediators, but there was no joint sessions. We never met the other side, ever. He went back and forth and operated what he called a zipper, saying, you go up 25,000, you go up 25,000. And that's how he got both sides to come up and down. And basically his fear factor was, do you want to settle this now, or do you want to spend $500,000 to get to summary judgment? And that's all it was. And our client was extremely dissatisfied because he said he wanted to meet the other person. He had a business plan, a business solution, saying they could do business together and maybe sell each other's products. He never had a chance to do that. He never met the other.
Well, you were his lawyer, right?
No, there was U.S. attorneys. So they were the ones who had chosen.
Well, no, but that U.S. lawyer should have put that proposal forward.
Well, yeah, he should have, but.
Nothing to do with the process, it's just lousy lawyer.
How do you really feel about it?
If the client had a solution, the lawyer should have put that solution forward to the mediator. Don't let the mediator start telling you what the settlement is. That's ludicrous.
Well, I agree with you 100%. But being in the U.S., you figure that U.S. lawyers do that. So that was great for the
Always trust Americans. Sorry.
On that note, we might wrap up. Actually, did anyone else have anything that they wanted to say?
Can I just say
or
one other
ask?
point about this California? Remember the
Yes.
mediators?
Yeah.
We were in a proposal. You were in the same one, right? In California, I mean, I talked about how wonderful they are and everything, but it's completely ridiculous. They do the shuttle diplomacy, and then at the end, they don't get a deal, and then they ask the mediator to come up with the magic answer. They call it a mediator's proposal. He pops a number out of his head, and then everyone's supposed to say yes. The Canadians in the room, there's about 10 of us, right? Our mouths dropped. And my comment was exactly the same. I said, you just got a bunch of lousy lawyers. They're just handing it to they're treating the mediator as if he was just the judge. And it sounds like that's what your guy was doing.
And the interesting thing, though, is, I mean, yeah, my jaw dropped. Although I will do mediator proposals, but only under certain conditions.
Yeah, like one side's already going to say yes.
Well,
right?
no, not necessarily, no. But if they, first of all, if they ask for it, if the
Right.
parties or the lawyers ask for it, and then I put a number of conditions on it, and it's not the way it ends. It's usually after the mediation's over, and I do a follow-up call, and then they might suggest it or I might suggest it. But yeah, it was interesting. And so again, though, and there's all sorts of exceptions to this rule, because we also heard from other mediators in California who said, no, that's not the way it is, and I do it differently. Southern California.
And
no, well, even within certain jurisdictions and within, you know, certain cities and towns and communities, I mean, there are different people who do different things. So you can only generalize so far, I think.
And actually, two of the four profs, instructors at the Harvard course I went to were from California.
Doesn't surprise me.
So
I mean, there really is a huge variety of styles, even within the same bar, within the same you know, province, state, country. Before we wrap up, is there anything else that anyone wanted to add? It could be baseball related. That would be good too. Man.
I just want to know, did that baby thing work earlier?
No, they didn't come, but yeah, it was awesome. I actually,
Use that next time, of course.
the woman brought her baby to the mediation. They were $2,000 apart. And it was a female HR lady in the other room. And I just brought the baby in as a prop and she held it. And I figured, I came back and said, your kid's a failure. Couldn't get you an extra. But
I didn't say that, did you?
I did. It's a nice kid, but he
You get away with
can't settle at all. And it adds levity, comedy, relaxing people through things like that. It's all part of my shtick.
And it is shtick. So
Oh, yeah,
Barry
totally.
is. I don't want to tell people you're a nice guy because then I'll ruin
You'll wreck my
your,
reputation.
but-
I guess
but,
that,
yeah,
that would
we'll
only
do
work for me, I guess, if they were twins, but we'll leave that.
That's interesting. Anything else before we wrap up? It is probably after 4:15. That was our end time. Thank you for
Thank you.
for everything. Thank you, gentlemen.